Welcome to Fredrikson and Byron. I'm glad you could all make it, and we're very pleased to have a lot of our clients here today. We really appreciate that you come and join us for these kinds of events. So we're very pleased to have you here. So we're going to talk about labor unions and the National Labor Relations Board this morning. This is basically a fairly basic discussion. And so if you've got questions, just raise your hand, and we'll take the questions as they come. This is being audio recorded for people who couldn't make it today. So speak loud. There are speakers in the ceiling that will pick up your voice. So let's talk about the National Labor Relations Board. The National Labor Relations Board was established by the National Labor Relations Act. Let me see if I can work this up. And that regulates the relationship between private sector employees, labor unions, and covered employees. So what does that mean? That means that basically almost every private employer, except for perhaps a mom and pop store, would be covered by the National Labor Relations Act, because it covers pretty much all private sector employees. It does not cover public sector employees, and those employees are typically regulated by state acts similar to the National Labor Relations Act. So the NLRA was established in 1935, also known as the Wagner Act, sponsored by Senator Wagner from New York. Try to work with this. It was created to administer and enforce the National Labor Relations Act, and it has regional and field offices. There's an office here in Minneapolis. It covers, right now, I believe, most of 5 states: Minnesota, western Wisconsin, Iowa, North Dakota, South Dakota. So it covers a wide area. There's a current move, and I'll kind of skip ahead a little bit. There's a current move by the current administration to create another layer of management between the central management in Washington and the regional offices, and they're looking to establish 2 divisions. We're not sure why, but we think there's some reasons that we don't really understand. In any event, there is the National Labor Relations Board consists of 5 members. 5 members that are appointed by the president. And by the way, you can follow the outline that's in the material. It's behind the stuff that we're showing on the board here this morning. So there are 5 members that are appointed by the president and confirmed by the Senate. Historically, it's always been that whatever party was in the White House, they would have 3 members assigned, and the minority would have 2 members assigned. And that results in a very political situation, if you will. So throughout the history of the National Labor Relations Board, the law keeps flipping back and forth from pro-management to pro-labor, pro-management to pro-labor, and cases get reversed all the time. The other thing you need to know about the National Labor Relations Board is, unlike other federal agencies, like the Department of Labor and all of those, OSHA, they have regulations that tell employers what they can and can't do. The National Labor Relations Act has very few regulations. The law of the National Labor Relations Board is based on cases that have developed over the years. And so cases come up. There would be, and I'll give you a perfect example. There's a kind of a doctrine called the Weingarten rights. I don't know if anybody has ever heard of it. Weingarten rights are rights that union employees have. If they're called into an investigative meeting, they have the right to ask for a union representative to be present during the investigatory meeting. That only applied to union represented employees. That law was changed at least 3 times to apply to non-union employees, then back to union employees, then back to non-union employees. So you can see how the politics move things around. Now, in addition to the 5 members, and the 5 members are the ones that decide the cases. And most cases have to be decided, all cases have to be decided by at least 3 members. And typically what you get is 2 members on the majority party and 1 member of the minority party on any given panel, and that's how the law tends to evolve and change back and forth. The General Counsel of the National Labor Relations Board is a little bit different. I'm jumping ahead a little bit. The General Counsel is appointed also by the President and confirmed by the Senate. And the General Counsel deals with the unfair labor practice charges and representation elections. Those are the 2 main functions of the National Labor Relations Board. They conduct industrial elections to determine whether employees in that particular group want to be represented by a union or not. So that's part of it's part of what they have got to do. So the General Counsel is actually independent of the 5-member board. And the General Counsel will determine whether cases are going to go to the board or not, basically, what cases are going to be issued, who's going to do what. So unfair labor practice charges are charges that can either be against the employer or the union. They are contained in Section 8 of the National Labor Relations Act. I'll talk about those in a minute. But first, I want to talk about the heart of the National Labor Relations Act, which is Section 7. Section 7 provides that employees have the right to join unions or not join unions, or to combine together for better working conditions without being a union. So there's a part of Section 7 that says that if an employee is engaged in what is called concerted protected activity, that might be something that if an employer discharges somebody, for example, that could be an unfair labor practice if the person was fired because they were trying to join a union or they were trying to stop the union from coming in. Either way. So Section 7 is the heart of the National Labor Relations Act, and it provides that you don't have to be in a union to be protected by the National Labor Relations Act. If you were involved in concerted protected activity, then you are protected by the National Labor Relations Act. We're going to talk a little bit more about concerted activity in a minute. So if you engage in an unfair labor practice, these are the things that the National Labor Relations Board said you cannot do. Employers are governed by Section 8A of the National Labor Relations Act. Section 8A is divided into 5 subsections. First subsection is just a general cover. If you engage in any activity that interferes with or restrains or coerces employees in the exercise of their Section 7 rights, that's a violation of Section 8A1. Section 8A2 deals with domination by the employer. If an employer establishes a union for its own employees, that's a violation. If an employer supports or in any way helps a union organize, that's a violation. Those are the things that come under 8A2. Section 8A3 deals with discrimination in the workplace. So like Title VII, for example, it's unlawful to discriminate against a person because of their union activities or their concerted protected activities. 8AD is to discharge or discriminate against somebody because they utilized the National Labor Relations Board to file a complaint or testified before the NLRB, kind of the retaliation provision. And Section 8A5 deals with negotiations between labor unions and employers. So those are the unfair labor practices that are against employers. In 1947, Congress passed the Taft-Hartley Act, which added unfair labor practice charges against unions. So for the first 12 years of the act, there was no unfair labor practice charge against unions. The Taft-Hartley changed that and basically added Section 8B, which is the section that deals with union violations. And 8B1 is kind of that general, again, restraining, coercing somebody within their Section 7 rights or causing to have employers discriminate against employees. a lot more limited unfair labor practice charges against the union. And then 8B3 deals with negotiations again between the union and management. So those are the unfair labor practice charges, and that is a significant piece of what the NLRB does. So if you have an employee, for example, that claims that they were discriminated against or discharged for engaging in concerted protected activity, then even if you don't have a union, you will be your company will be investigated by the National Labor Relations Board if there's a charge. So just not having a union does not mean you're not going to get some kind of activity from your non-union employers that could impact their rights under the National Labor Relations Act. So protected concerted activity is the rights of employees to engage in concerted activities for mutual aid and protection, and activities of employees who have joined together to achieve common goals. That's not a union. That's not a labor organization. Those are individuals who act in concert. So if somebody, and we'll get into this when we get into the social media issues. What's unprotected? That's kind of important. Unprotected activity, attenuated connection means there's only a real remote connection with concerted activity. And it's so remote that the board says it's not a concerted activity. Impermissible means or goals, that means if there's violence or to achieve an unlawful goal, such as a discharge of a coworker because of the coworker's position on union. So that's an impermissible means or goal. Disloyal, reckless, or maliciously false statements, and you got to be careful on this one because you'll see that there are some that are problematic, and that's anything that is intentional, disloyal, reckless, or maliciously making false statements is not going to be protected under Title 7, under Section 7. And public disparagement. There was a case recently talking about public disparagement. Many of you may have heard of locally the Jimmy John's case, where employees were trying to organize with the Wobblies, if you know what I'm talking about, workers of the world. These are really radical people. Anyway, they went through an organizing campaign at some of the local Jimmy John's. And some of the pro-union employees engaged in activity that was not very nice. They made some very negative comments and statements, and they were doing things like, if you're sick, you can't call in, and you get no sick leave, so sick employees are coming to work and they're making your sandwiches. They also were spitting on the sandwiches and serving them to the public. That took it out of protected activity. And actually, that went all the way up to the 8th Circuit Court of Appeals in an en banc decision, which reversed the Labor Board's decision, reversed the District Court's decision, reversed the 3-judge panel decision. En banc means all the judges of the 8th Circuit got together and decided, no, this is not a violation of the National Labor Relations Act. This is outside the scope of Section 7 rights. And then finally, disruptive, profane, or vulgar behavior. And here the board considers four factors: the place where the discussion took place, the subject matter of the discussion, the nature of the employee's outburst, and whether the outburst was in any way provoked by an employer's unfair labor practice. There was a case in 2015, a catering company that violated sections 8A1 and 8A3 of the Act when it terminated an employee profanely attacking and insulting a supervisor on Facebook. And this is what he said on Facebook. And this is a quote: "Bob is such a nasty M&F'er," and you know what I'm talking about, "don't know how to talk to people. F his mother and his entire effing family. What a loser. Vote yes for the union." Is that protected? It was. NLRB said because it had vote for the union and it was sent out in the context of a union organizing campaign, that was protected conduct. So be careful about profane, vulgar comments doesn't mean it's not protected conduct.
Would that have been different had it been said in a meeting on site? Does the location of Facebook for those comments make them more protected than in the actual workplace?
No, I don't think it matters what venue it's in. It's going to be protected no matter what, assuming you're talking about win the election, something about the union. That kind of gives it the protection. Now, so one of the things that the board has determined, let's see if we can get there. So old rules and new applications. So email and the use of company equipment. So you have a non-union operation and you have employees that are, clerical in nature, administrative, rather than production workers. They're sitting at a desk, they've got a computer, you've got an email system, and part of that, you allow your employees, or maybe you're not even aware, that they're using your email system for personal reasons. They're communicating with their friends, their family. The NLRB, in a decision a couple of years ago called Purple Communications, held that if the employer has an email system and permits the employees to use the email system for personal reasons, they must allow the employees to use the email system for organizing union activities or other concerted protected activities. So that was a decision that came down, and basically it said it does not prevent employers, however, from notifying employees that it reserves the right to review work computers and emails for legitimate management interests, and they should have no expectation of privacy in either, and monitoring computers and email systems for legitimate managerial reasons, such as ensuring productivity, preventing email use for harassment or other activities that could give rise to employer liability. So there are some things that you can do with your emails, but it does prevent you from disciplining or discharging an employee for using your email system for union organizing or to engage in concerted protected activity. The internet. Boy, now we've come across a real problem. Internet use, blogging, and social media. The board, the NLRB, considers whether the communication was in the nature of an individual gripe or complaint or something broader that involved others. That's really the key to determine whether it's concerted. So there's a case involving Chipotle last 2 years ago, actually. Chipotle requested that employee remove tweets that he had put to the company communication director about requesting a snow day. Chipotle requested the employee to remove the tweet showing him a version of a social media policy which prohibit employees from sharing confidential information. Confidential information. The board held confidential information is too vague, and therefore it could violate the National Labor Relations Board unless confidential was adequately defined. So it also violated the National Labor Relations Act because, among other reasons, disparaging language could easily encompass statements protected by the Act. So there is in the outline on page 7, by the way, a memorandum, a link to an NLRB memorandum, which provides guidance to employers on social media. I recommend that you download that and review it because it can be very helpful. This is an area that's evolving, and we don't know where it's going to end up. And in addition to regarding Section 7 rights, social media cases raise the issue of whether an employer has engaged in unlawful surveillance, interrogation, or made threats to the company through social media. All of those would be unfair labor practice charges. Finally, gossip, confidentiality, complaints, and grievances. Confidentiality policies that explicitly prohibit employees from discussing their wages, hours, terms, and conditions of employment is a violation. Now, in Minnesota, that really doesn't have that much impact because Minnesota passed a statute in the last few years that mandates employers cannot prohibit employees from discussing their compensation. Under the National Labor Relations Act, that's even broader. It's their compensation, benefits, terms and conditions of employment. Employees are free to discuss that with basically anyone. So keep that in mind. Policies that don't explicitly prohibit discussions of terms and conditions of employment can also be unlawful if they're susceptible to being construed as restricting discussion of those subjects or have been applied to restrict those behaviors. So here's a couple of examples, and I'm going to read these because these are kind of critical. Examples of confidentiality policies held unlawful. And some of this may sound familiar to some of you, unfortunately. So the first one is any and all information regarding businesses, employees of Interdisciplinary Advantage, Inc., that's the name of the company, and or individuals serving in Ida Homes, which is conducted in this office, is strictly confidential. That was unlawful. Here's one. Disclosure of confidential information gained through your employment by the hospital is considered an act of prohibited conduct, subject to formal disciplinary action. Any information concerning a patient's illness, family, financial condition, or personal characteristics is strictly confidential. When a patient's history or condition is reviewed, it must be done in privacy and with only those persons involved with the care of the patient. Any other information coming to you in the course of your work concerning another person or employee is also considered confidential and may not become the topic of conversations with others. Very broad, talking about interaction between employees, clearly protected conduct, that they said this confidentiality policy violates the National Labor Relations Act. Here's an example of confidentiality policies that were held valid under the National Labor Relations Act. You're responsible for the appropriate use and protection of company and third-party proprietary information, including information, assets, and intellectual property. Information is in any form, printed, electronic, or inherent knowledge of company or third-party proprietary information. Intellectual property includes, but is not limited to, and then it has a laundry list of bullet points. While it's not improper for you to use proprietary information in the general course of doing business, you must safeguard it against loss, damage, misuse, theft, fraud, sale, disclosure, or improper disposal. Always store proprietary information in a safe place. You may not use or access the proprietary information of the company or others for personal purposes or disclose non-public information outside the company. Doing so could hurt the company competitively or financially. That was held to be a lawful policy. So those are examples in the outline. So non-fraternization and harassment. Again, this is an area that, again, you don't have to be unionized to fall under these issues. So fraternization involves a case Guardsmark, the NLRB issued a policy. It said that a policy that prohibits employees from dating or fraternizing on or off duty is prohibited. Anybody think that was violating the act? Well, the NLRB said it was. It was because the word fraternize may be understood to mean associate, cooperate, join, or unite, words that fall within Section 7. So that was why that particular policy was held to be unlawful. So employers often implement rules prohibiting employees from engaging in this kind of harassment and conduct. But rules prohibiting false, vicious, profane, or malicious statements towards the employer or any of its employees were found unlawful in certain instances because they tend to have a chilling effect on Section 7 rights. By a rule directing employees not to fraternize with hotel guests on hotel property was found to be lawful in that particular case. In another case, the board held that prohibiting disloyal, disruptive, competitive, or damaging conduct, prohibiting slanderous or detrimental statements, and requiring employees represent the employer in a positive manner did not violate the act. So you can see, these cases tell us that every situation is going to be resolved on a case-by-case basis. there is no bright lines, generally speaking. So you have to analyze all of the situations under the idea of Section 7 rights. And keep in mind, the NLRB takes a very broad view of Section 7 rights. Now, when we have change of administrations, that view tends to shrink and expand again with the politics of the country. Dress codes. A neutral dress code policy that is uniformly enforced is permissible and lawful. On the other hand, employees generally have the right to wear union buttons or other union designated shirts, t-shirts, whatever, unless the employer can show that a restriction on those on wearing buttons or other union insignia is needed as a matter of safety, production, or other legitimate business reasons. So typically, dress codes, you have some limitation on what you can prohibit employees from wearing. Solicitation and distribution. This is an area that you probably have some familiar with if you have an employee handbook. And if you have an employee handbook, there's a good possibility you have a section dealing with no solicitation, no distribution. So solicitation is just what it sounds like, where somebody comes to you and tries to get you to join the union, and that could be in a variety of ways. That could be face-to-face, it could be over the phone, it could be through the internet, lots of ways that that can happen. And distribution talks about basically hard copy pamphlets and writings that may be distributed by unions when they attempt to organize. So solicitation is a very specific thing. A rule that prohibits solicitation by employees during work or during working time, and these are terms of art, is presumptively valid. So I'll repeat that. A rule that prohibits solicitation by employees during work or working time is presumptively valid. So if somebody is supposed to be working, then they're not, and you have a no solicitation rule, then they're not supposed to be engaged in soliciting other employees. There are, however, situations where employers say, you know, in a more general sense, no solicitation while at work. Well, while at work encompasses non-work time. And the NLRB says employees have the right to enjoy their Section 7 rights on non-work time. So that's the term of art that you have to be familiar with. Now, distribution, again, basically says that if you allow entities to come into your premises and solicit employees for a variety of things, Girl Scout cookies, local, raffles and those kinds of things, then you're exposing yourself to allowing unions to come in. So you need to be very careful about having a no distribution rule. I've had cases where the unions try to organize and they leave leaflets in the lunchroom. And the employer, thinking that they had the right, they confiscated those leaflets and discarded them. That's an unfair labor practice. So you have to be very careful about what you do. If you get into one of those situations, be sure to contact your labor lawyer to make sure that you can do what you want to do. I had a client that engaged in probably over 50 individual unfair labor practices before they contacted us. So it was a little bit too much too late. There are some special rules about solicitation and distribution depending on the type of industry. So in a retail business, you go to a store, you can have a prohibition that employees cannot solicit on the sales floor, period, even during non-work time, because there are customers, and that could be disruptive to a retail operation. There's also a specific rule related to health care institutions, and those basically say that hospitals prohibit union solicitation in their facilities by allowing hospitals to exclude union organizing activity in patient areas. as well as patient care areas. So that's kind of the functional equivalent for the retail on the floor. And of course, non-discrimination, you cannot discriminate against anybody. If you have a valid no solicitation, no distribution rule, if you apply it discriminatorily, that's an unfair labor practice. And Benefit Acts exception is what's sometimes called the United Way exception. If you allow United Way or some similar organization on a very limited basis to solicit on your premises, the NLRB has said we'll allow very few of those, but if you only have a couple, one or two, and it's not constant, then that will violate your no distribution rule, and that's valid. So in that, you can have it in that situation. So Section 7 rights can be implicated by explicit restrictions, chilling effect, and improper applications, which we just talked about. How are we doing time-wise here? We're doing great. We're going to have lots of time for questions. Okay. So access to company property. I want to talk about that before we get into the next slide. A policy that prohibits employees access inside working areas by off-duty employees is generally lawful as long as it's applied in a non-discriminatory way. In a case that was held in 2003, the NLRB held that a handbook provision prohibiting employees from entering company property after hours without authorization was unlawful. Why? Because company property included the parking lot and exterior of the building, and you cannot prohibit somebody from coming into your parking lot. Basically, it's a public area. So they held that to be unlawful. Here's one that I love. Non-employee union organizers. Private companies can prohibit access to their premises by non-employees, including union reps, if there's reasonable alternative channels of communication are available for the union to communicate with the employees. The company doesn't have to discriminate between protected union and non-union activities when restricting access to its premises. Keep in mind, if a union rep wants to come onto your premises, the owner of the premises, if you lease your premises, you're not the owner, you're a leasee. And it's the owner of the facility that has the authority to bar anybody to come onto the premises. But there's got to be alternative ways for the union reps to be able to communicate with employees. And the NLRB has held things where employees can meet and communicate on the premises if there's no other available means for them to communicate. So sometimes they can come into your premises, or at least just outside your premises, in an effort to organize. I'm also going to be talking in a few minutes about salting, which also deals with union organizers who seek to become employed by the employer. I want to talk a little bit about, well, let's go back to what's on the board here. Communications about wages, hours, and other terms and conditions of employment. These are all things that we've already discussed. Work stoppages and walkouts. We have walkouts by non-union employees may be protected. So if you have a group of employees that, there's a case a long time ago where there was a factory where it was a very hot factory, and it was a particularly hot day, probably 100 degrees or more, and a group of employees in this factory said it's too hot to work, and they walked off the job. They were all fired. The NLRB held they were unlawfully fired because they engaged in concerted, as a group, protected, they were objecting to conditions of employment, concerted protected activity that was not, that the employer fired them was a violation. Okay. And a violation can be found even without unlawful intent if it's clear on its face that the employee is engaged in that protected activity. Now, there's also mandatory arbitration policies that many employers are starting to institute to avoid litigation. This is a problem under the National Labor Relations Act. Depending on what your arbitration policy states, you may or may not have a problem with the National Labor Relations Act. If there is a mandatory policy that all claims have to be arbitrated, that's going to be a violation of the National Labor Relations Act, because it is statutory that employees have the right to file charges with the National Labor Relations Board. So if you have an arbitration provision, either in an employee agreement or in a handbook or a policy, you better make sure that it is not in violation of the National Labor Relations Act. If it could reasonably, if employees could reasonably perceive that they no longer have the right to file a charge with the National Labor Relations Board. And those of you who are clients, you will probably know whenever we've helped put together a settlement agreement or a severance agreement, we address that issue in the agreement by specifically stating that the employee has a right, still has a right, despite this settlement agreement and waiving all their claims, they still have a right to file charges with the NLRB, as well as the EEOC, as well as other agencies. So there's an exception carved out for those situations. Okay, so I want to move. Okay, we're having a little technical difficulty here. Let me see if I can get somebody to fix this. Hold on. Stop. Sorry for technical difficulty.
It just blinked, so maybe it was just frozen.
Yep.
And not even the arrow up or down is working.
Yeah. So we're getting IT. We'll continue. Okay. So communications about wages, hours, and other terms of employment. The board has held that employees who complained about favoritism, wages, and bonuses are engaged in protected activity.
They have copies.
Okay. 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 All right. I know where we are here. Okay. So employees have the right to engage in concerted communication with third parties regarding legitimate employee concerns, such as terms, conditions of employment, and grievances. Work stoppages and walkouts. Again, we talked about this. And the case that I was talking about is in the materials, Washington Aluminum, where the employees walked off the job because of the heat and the working conditions. That was protected activity. And again, violations can be found even without an unlawful event. In a case in 2005, a group of non-union employees met behind their employer's warehouse to discuss the absence of a wage increase, perceived favoritism and racial prejudices at their workplace. They went on strike until their supervisor came out to meet with them and talk to them. However, the supervisor came out and fired them, and the NLRB found that that was an unfair labor practice. Those employees were fired for engaging in concerted protected activities. Okay, thanks. Okay, so here are those situations. Leaving work early in violation of an employer's attendance policy to attend union meetings actually is not protected activity. You would think it was, but it's like going to a seminar. If they were going to union training, that's not protected activity because it doesn't deal with the terms and conditions of employment at that place of employment. So leaving work early to attend a union meeting is not protected activity. And concerted activity can be away from the workplace as well. It's not limited to issues specific to the immediate employer-employee relationship. The NLRA also protects employees when they seek to improve their lot as employees through channels outside the immediate employer-employee relationship. The Supreme Court noted employees of petitioners sought to distribute a union newsletter in the non-working areas of petitioners' property during non-working time. The fact that the activity occurred on the employee's property was an important source of discussion. So in that case, concerted activity can be away from the workplace, and of course, social media in many cases is away from the workplace, and that can involve unfair labor practices that engage in concerted activity as well. Again, can be among employees of different employers, and if you have employees that are supporting other employees from a different employer, that can be protected activity. Again, political advocacy. Most of you remember many years ago there was a mass walkout, a day without immigrant rallies throughout the United States, and that led to numerous unfair labor practice charges. The board assumed without deciding that employee participation in the demonstration was protected by the National Labor Relations Act under the Mutual Aid and Protection Clause of Section 7, but recommended dismissal where an employee violated a company policy such as no call, no show. So keep that in mind. The General Counsel explained that in determining whether an employee who is engaged in political activity is protected under the Act, the regional directors will look to see if there's a specifically identified employment concern that the employee is advocating for. So the General Counsel provided the following, and I'll read this. Political advocacy related to specifically identified employment concern that occurs during non-work time in non-work hours is generally protected. On-duty political activity related to a specifically identified employment concern may be subject to restrictions imposed by lawful neutrally applied work rules. And leaving or stopping work to engage in political advocacy related to a specifically identified employment concern may be subject to restrictions imposed by lawful neutrally applied work rules. So that is political advocacy. Again, be careful in disciplining or taking any action against a person engaging in political advocacy because it depends on what they do and what they say. Interviewing and hiring. So it's an unfair labor practice for an employer to encourage or discourage union activity or union membership, and that's under sections 8A3 actually, and 8A1. An employer cannot refuse to hire a qualified job applicant solely because the applicant is a union member and is a union official. So this is what's called salting. And interestingly, the lead case that went to the U.S. Supreme Court came out of Minnesota. It was Town and Country, was a situation where a union business rep applied for a job at Town and Country and said he was a professional union organizer. And he applied for a job. And during the interview, he told the employer that he was there to organize the employees. Well, needless to say, the employer refused to hire the guy, and that case went all the way up to the U.S. Supreme Court that held it is an unfair labor practice for an employer to refuse to hire a union advocate who intends to organize your employees. It is called salting. Now, having said that, there is a limitation, and the limitation is a union salt will not be protected if he or she does not have a genuine interest in obtaining employment. How do you determine that? Do they just say they're interested? Do you have to go back and say, are they currently being paid by the union? Are they being paid by another employer? There are lots of factors that go into this and to determine whether or not a salter has to be hired. Keep that in mind. If you get into that situation, hit pause and call your labor lawyer, find out what you should or shouldn't do. Those are really kind of critical. Employer grievance committees, domination or interference with labor unions. Some of you may recall some 20, maybe 25 years ago, there was this whole movement about having committees among the employees to talk about terms and conditions of employment and how things can be improved. Well, guess what? All of those committees in which employees and management sat together and talked about, discussed terms and conditions of employment, all of those committees were found to be unlawful unions and had to be disbanded. So it's an unfair labor practice for an employer to set up these committees to discuss with employees the terms and conditions of employment. There's one exception, and that one exception is safety committees. And safety committees can be set up, but you have to be careful that any interaction with employees has to be deemed suggestions by the employees to management. You can always have a suggestion box or a suggestion safety committee. That's not unlawful, but pretty much anything else that the employer puts together where employees and managers sit together and talk about how we can improve terms and conditions of employment, that's problematic. Safety is viewed somewhat differently. Now, the definition of a labor organization is a lot broader than you think. The definition of a labor organization exists if the employees participate in the organization exists at least in part to deal with employers, and those dealings concern wages, hours, or other terms and conditions of employment. And I will tell you that there are some organizations out there that it's questionable whether they're unions or not. They may be advocacy groups on behalf of workers, but if they start engaging in discussions with employers, that may convert them into labor organizations. But you don't have to be a union to have a labor organization. They are different thoughts. So let's talk about some of the things that affect collective bargaining agreements and mergers and acquisitions. This only applies if you're selling or buying an organization, and there are specific rules that deal with those situations. So stock purchase of an existing organization means that the buyer literally steps into the shoes of the seller. The collective bargaining agreement remains unchanged. In an asset purchase deal, the buyer is only buying the assets of the seller, and therefore it is not obligated to assume the collective bargaining agreement. Rather, it now has a requirement to recognize the union as the representative of its employees and bargain with the union to get a new collective bargaining agreement. So that deals with the sale of business, purchase of business. I don't know that that has anything to do with any of you, but just in case you're involved in one of those, keep that in mind. So we're moving along here. So sometimes the successor clause in a collective bargaining agreement may bind the purchaser. I would argue it depends on what the language is in the collective bargaining agreement, whether it's binding, because under normal contract law, if a buyer comes in, they've not agreed to the terms in the prior collective bargaining agreement, so they shouldn't be bound by it. Now, some of you may recall a couple of years ago under the Democratic NLRB that the NLRB tried to issue a rule this was something new, that would have required private sector employees to post a notice similar to the Title VII notice, ADA notice, workers' comp notice that you all have next to your punching clocks or wherever. Those would be required. Very similar, basically laying out in somewhat detail what employees' rights are under the National Labor Relations Act. That decision, that case went all the way up to the U.S. Supreme Court, and the U.S. Supreme Court basically invalidated the NLRB's notice posting rule, which would have required that posting. If you're interested in what the notice would have said, again, there's a link in the outline on page 19. So that's probably not going to happen now for some period of time, because as of last week, the 5th member of the National Labor Relations Board was finally approved by the Senate. And so now there are 3 Republicans and 2 Democrats as the members of the National Labor Relations Board. However, remember I talked about the Purple Communications case involving email. That case was reversed by a 3-member panel. One of the members who was sitting on that panel, a Republican appointee, had been an attorney previously with the law firm of Littler Mendel, and the case that the Purple Communications case was, the employer was represented by Littler Mendel. And so there was a conflict of interest by that particular member, and as a result, the Purple Communications decision was invalidated. And then ultimately the Supreme Court ruled, no, you can't. So look at that. Look at the rule that's in the outline. There's a link there. So we're getting really close to the end here. So that was what they were trying to do. Workforce consisting of 24 speak a language other than English. The notice must be in the language that the employees speak. So that could be Hmong, could be Spanish, could be any other language. That's what they were proposing. So, new directions and rollbacks from the NLRB. So the new General Counsel, who's a Republican appointee, has ordered the regional offices to look at cases in the past 3 to 5 years under Democratic control that reversed earlier decisions under Republican control. The General Counsel wants the regions to send those cases in to determine whether they should pursue them and, in effect, reverse some of those decisions. Again, the political swing going back and forth depending on who's in the White House. So there is a General Counsel Memorandum 18-02, which sets forth the guidelines for regional office to follow when submitting cases to determine whether they should pursue an unfair labor practice charge or not. Again, I've included the link to that General Counsel's memorandum on page 19 of the material under new directions and rollbacks for the NLRB. The new General Counsel specifically wanted, and again, specifically identified cases that relate to, and this is how he put it, significant legal issues, including cases over the last 8 years that overruled precedent and involve one or more dissents. So again, they're fishing. General Counsel is fishing for cases, again, to flip back the decisions that the Democrat majority had ruled and flipping them back again. The memo, the General Counsel's memo also takes aim at the employee handbook policies which have been found to be unlawful, specifically identifying policies prohibiting disrespectful conduct, which could clearly include Section 7 rights, employee use of employee trademarks and logos, employee recording of meetings, and rules requiring employees to maintain confidentiality of workplace investigations, among other policy cases. So the NLRB currently, the current law, under case law, in terms of confidential workplace investigations, under the National Labor Relations Act, you cannot require complete confidentiality of investigations involving employees. They have the right to talk to their coworkers about terms and conditions of employment, which includes any grievance that they might have. So that would not be an unfair labor practice. Employee handbooks. You all, I would assume, you all have employee handbooks. And one of there was a recent case in Lutheran Heritage standard that policies that are contrary to the act, if they could be reasonably construed by an employee to prohibit the employee from exercising their rights under Section 7 of the Act. So again, you've got to scan your employee handbooks or have somebody that knows labor law to review your handbooks to make sure there's nothing in there that could in some way inhibit employees, or they have a sense that they can't do certain activities which might be protected activities. So again, the handbooks can be very important, but the NLRB now starts looking at handbooks when they get charges to see if there are any unlawful provisions in the handbook. So keep that in mind. Joint employer test. This is a very hot topic right now. And this involves a case called Browning-Ferris. It involves who is the employer in particular situations. So if you've got a franchise operation, or franchisee, or you have a contract, subcontractor relationship, these could involve a joint employer test. Under the old rule, under the old rule, if the franchisor or the contractor has the right to engage or at least enforce some policies on the franchisee or the subcontractor dealing with employee rights, if there is the right to do that, but not having ever done that, the old law said that was not a problem, not a violation. So now, under the Browning-Ferris case, the NLRB, under, again, Republican majority, under the Democrat majority previously, held that the employer, the franchisor, actually does enforce some rights on the franchisee or the contractor on the subcontractor. So it has to be actual. So it's an entity was only deemed a joint employer under the NLRA if it had directly and immediately exercised control over the essential employment terms of the other entities. So that was the old rule. I'm sorry, that was the old rule. If the NRA, it's a violation if it directly and immediately exercised control over essential employment terms of the other entity's employees, that would make it a joint employer. Under the Browning-Ferris rule, the board held that in order to establish that relationship, the mere indirect potential control would be enough. So if McDonald's, and that's the case, has the right, that hasn't exercised it, but has the right to impact the employees at a franchisee, under the Browning-Ferris decision, that would result in a joint employer. Both employers would now be liable. Well, you can imagine that franchisors like McDonald's are like going out of their mind because they've got tens of thousands of franchise stores. If they're a joint employer with all of those stores and those stores get organized, they're going to have to sit at 10,000 bargaining tables and negotiate separate contracts. A complete mess. So keep in mind, joint employer is something that's open right now. It's going up to the Supreme Court, and we'll ultimately find out what the ultimate rule is. But my suspicion is under this board now with the Republicans in charge, we'll revert back to not just having the right to exercise, but actually exercising. to create a joint employer. Any questions so far? Because I think I'm just about done. No question. Yes.
On the subject of respect, it's like putting something about respect in the employee handbook or whatever. There, I don't know how to explain it, but like our work culture kind of got in the habit of complaining about everything. Like anytime a supervisor asks them to do something, they say, "Why do I have to do? Why not anybody else?" And like it got to be like really out of control. So we kind of built it into the performance management. Like so we would kind of rank people on the performance, various aspects of it. One of them being respect or cooperation with supervisors. Would that actually be unlawful?
Well, one, it probably depends on how it's enforced. That's even if it's neutral or not violative on its face, if it's enforced discriminatorily, that could be a problem.
Well, it gives them a ranking that would ultimately decide their pay raise.
Well, again, keep in mind that individual gripes. I don't like how I'm paid. I don't like the working conditions. I want a change. That's not protected because it's not concerted. Now, if I say, me and my fellow workers want something or need something, that's concerted, and because it deals with terms and conditions of employment, it would be protected. So that's the distinction. If it's an individual who's complaining about how they're being treated individually, that's not a violation of the National Labor Relations.
I have one other question.
Absolutely.
There was one where you said something about leaving work early to work on union-related things. What about like a work flow, like you're not starting your work fast enough? So like we have drivers who are union and then they would sometimes delay 30 minutes or so because they're doing union conversations in the parking lot. Is it unlawful to like prohibit that since their work has started, or to tell them that it has to be in a particular location, like scheduled, or like we're trying to?
Good question. I think a lot of it depends on what they're discussing. But if you've got a policy that says you're supposed to be at work when you're supposed to be at work, you can go out to the parking lot and say, guys, get to work. And if they don't get to work, then they're not following proper supervisory directives. And they can be disciplined. Merely because they're in the union and they're talking about union business doesn't give them the right to do that on company time. You're paying for them to be out there. Now, if they come to the parking lot before work, before they're required to punch in, and they're talking amongst themselves, that's perfectly lawful, and you cannot stop them from doing that because they're not on work time. They're not working and punched in. That happens. More questions.
But what if they're late because of that?
Then you would discipline them for being late.
So if they're punched in, like if they're punched in and they're working,
yeah,
they
that
cannot be doing their work.
If they're not working, you can tell people to go to work. If they're supposed to be working, it doesn't matter what they're talking about. If they're supposed to be working, they're supposed to be working. Go on, you got to have more questions than that. Well, we're going to, yes.
You mentioned not bringing kind of management and employees together to determine, ideas or
They used to be called quality committees, or something like that. It was something that the Japanese had created, and we were involved in it maybe 20, 25 years ago.
Right. If there's to come together to like try to improve your benefit packages, those kinds of things, and there's ideas expressed, is that something different?
No, that could be protected activity. Absolutely. Okay. Absolutely.
So if it's just them giving ideas, but if you take on what they're saying, I mean, where is the
if employees provide suggestions to management in whatever format, that's fine. But when you start having a discussion between management and employees about terms and conditions, then they're discussing terms and conditions of employment.
Got it.
And that creates protected activity, and so that's where it ends up.
And then, so what happens after that? I mean, so you came together, you're non-union, you're having those discussions,
right?
And we're all good at the end, then nothing. right?
Well, if you're doing it off premises or not on work time, those are lawful. But otherwise, when somebody's supposed to be at work, like I said, they're supposed to be at work. And again, if you have no solicitation, no distribution policy, that clearly says, you know, during work time you cannot be solicited. And that would be considered soliciting a discussion between two employees about unions. Clearly, that would be covered. Question?
My question is in regard to dues,
You thought?
union dues.
Yes.
So we have long-term substitutes that now the union is telling us have to pay dues.
When you say long-term substitutes,
I mean, in public education,
okay,
so they're working 20 or more days,
right.
but it could be just 20 days.
Now, if they're in public education, they're not going to be covered by the National Labor Relations Act. In Minnesota, they'd be covered by the Minnesota Act or per Public Employees Relations Board.
Okay.
Although those rules are very similar to the NLRA, they're not identical. And for example, in Minnesota, I don't believe there's any basis to bring a claim against unions under the Minnesota statute.
I'm sorry to belabor this point, but in regards to groups of employees coming together with management to talk about like employee engagement,
Right.
I'm having difficulty really understanding where the line is between like working together and when it could potentially get us in the hot water, because topics could range from here's our engagement survey and here's what the scores were in certain groups and what do we think is going on, and then also what about our travel policy? We don't like how this is written.
Again, if they're individual gripes, it's not going to be protected unless they're griping on behalf of themselves and others. That would be considered. But if it's an individual, it's not going to be covered. I'm not sure that's answering your question, though.
Right, because it's a committee that comes together, like
Okay.
engagement,
So you've got an employee committee,
and some members of management.
and what do they do?
Talk about whatever's on the employees' mind that they're concerned about, and or our employee engagement survey and the results of that, and how to potentially make improvements in the organization. If they have a policy that we've implemented they don't like.
Yeah, if you've got a committee of employees and managers and they are discussing terms and conditions of employment, very broad definition, that is likely to be an unlawful committee and deemed an unlawful union or unlawful labor organization, basically, and would have to be dismantled. The only committee that employers can legitimately have where they discuss things is safety committees, and even that has its limitations. So the committee that you're talking about is probably unlawful. Now, it's like the proverbial tree in the forest. If nobody complains, who cares? But if somebody complains, if somebody is upset with how things are going, yeah, they could file a charge and disband the committee.
So if it's one of the, oh, I'm sorry. Go ahead. No, go ahead.
I'm on the same topic too.
Yeah.
Does it make a difference if it's developed by management to gain feedback because you're looking for it, because you need it to be able to write a policy, or like if it's initiated by employees?
It doesn't matter who it's initiated by. What really matters is what is its purpose and what does it do. Again, you can have what we call suggestions. So if you need employee input on terms and conditions of employment, you should solicit it and get a suggestion box or have them email suggestions, whatever it is. That's okay, because that's merely telling the employer this is something that we'd like you to do. Now the employer doesn't respond to that because that creates a dialogue, which is problematic. The employer says, thank you, we'll take that under consideration, and then evaluates what they want to do and then takes whatever action they deem appropriate.
With that, I mean, what if it's just like a one-time meeting, just soliciting suggestions? Is that not considered a committee, and that's okay to just?
Yeah, if you can have either individuals or group meetings and say, look, we are interested in hearing if you have any suggestions, and you can orally tell us and we'll write them down, or you can submit something in writing and we'll consider it. But you don't have a discussion. You just say, thank you. And you take the suggestions and evaluate. Another question.
Oh, no.
Can I just ask why? What's the reasoning behind that, or why would that be considered unlawful?
It's unlawful because under Section 882 of the National Labor Relations Act, it's unlawful for an employer to dominate or support a labor organization. Remember, a labor organization is defined very broadly to include two or more employees that are coming together for mutual aid and protection and to discuss terms and conditions of employment. So keep that in mind. Any more questions? I see perplexed looks.
I think a lot that this really is throwing a lot of us from an HR perspective. I think if you probably did a show of hands, how many of us have this kind of committee in our organization?
Yeah.
Probably.
Anybody else have committees that they? Yeah. If you have a committee and that committee is composed of employees, rank and file employees, and management representatives, and they are talking about terms and conditions of employment, and employees are saying to managers, you know, we really need to change this situation, or so-and-so should get, you know, promoted or whatever. Those are all discussions that are protected by the National Labor Relations Act, and it would be unlawful to have the employer dominate or support that committee, which would be viewed as a labor organization.
Would you say if the committee was more focused on morale, how to build engagement throughout the organization, which those aren't terms and conditions, but more of atmospheric things where, you know, birthday celebrations, parties, those type of committees are okay. If in those discussions, an employee says, you know, employees around here are feeling like the attendance policy is, you know, causing work to suffer, outside factors, then you would then say, you know what, have that further conversation with your supervisor, who can then bring it to the management team to review.
Right.
So not necessarily having a committee where employees and managers come together to talk about overall morale things, engagement. You're not talking about terms,
right.
But then if those conversations come up, then you redirect them to their supervisor to then bring it forward to the leadership team.
Absolutely, absolutely. So again, keep in mind that in order for the committee to be in violation of Section 882, there has to be discussion of terms and conditions of employment. If you have a committee that is formed to celebrate birthdays or retirements, that's not going to be covered. But once you get into things like attendance or the sexual harassment policy or the bullying policy, and these things need to be, you know, changed or looked at. Once you start having those discussions, technically that's a violation of 882. But again, employers violate the National Labor Relations Act probably on a daily basis, and nobody knows it. The employer doesn't know it. The employees don't know it. And the reality is that traditional labor law, which I grew up with, traditional labor law, there are not a lot of new lawyers coming in that are skilled in labor law. So it's mostly, and I don't mean this pejoratively, but it's mostly older white guys who do this. And so there are not a lot of what I would call plaintiff lawyers out there that practice labor law as well as employment law. So most attorneys that are representing your employees, plaintiffs, those attorneys by and large focus almost exclusively on employment law and employment litigation and not labor law, which is a different animal. And so you can see that labor law can have a significant impact. And that may change a little bit under the Trump administration, where the Republicans start to constrict some of the regulations and the applications. But keep in mind, employees have these Section 7 rights. That is the core of the National Labor Relations Act. Employees have the absolute right to join together for mutual aid and protection, to discuss terms and conditions of employment, and not be disciplined or discriminated against for engaging in that activity. And that kind of covers the whole area.
So in our work environment, we're a medical facility. We're spending a lot of time on culture, which is not as an ethnic culture, but as in working together to streamline, to gain efficiencies. So we have and have promoted a fair number of these committees that work together, maybe in a pediatrics department, and the nursing and doctors and management of the crew all get together on a regular basis, probably monthly or whatever, and say, okay, so how could we streamline this? How can, patients get in and out of the system easier, whatever. That would seem to be a direct violation of that.
Maybe not. Again, it depends on how it's enforced. On its face, it may not be unlawful if they're talking about medical issues as opposed to working issues.
Right.
So you have to kind of.
So we might be able to hang our hat on that, is what you're saying?
I mean, if the purpose is to improve the medical process,
right?
It probably would be okay, but it depends on really how it is enforced and how you.
Right.
How it works.
I apologize if you went through this, I came late, but for the email portion, let's say we have a no solicitation policy, like you can't ask for donations like in your GoFundMe or your YouCaring site. So let's say an employee posts about it during non-working hours, either through email or on like our internal social networking board. It's non-working hours, but it's still a violation of our policy. Can we enforce that to say you still can't do that, or you can't send it out, or we're going to take down the post because you can't solicit?
If the employee, let me back up. If the company permits employees to use the email system for personal communications, they must allow the employee to use the email system for union organizing activities or protected activities. Okay? I don't know if that answers your question directly or not.
So if they are emailing their break time, so non-working hours.
If they're on non-working time and they send an email to other employees.
Yeah, to say, hey, I have this GoFundMe account.
Yeah. If the employer has a policy that allows employees to use the email for personal reasons, yeah, employees can use it to go fund or whatever, as long as they're doing it on their non-work time, and any of the employees that are interacting with that email are also on their non-work time. Perfectly lawful.
And the same will hold true for like an internal, like social media board?
Yeah, again, as long as it's in non-work time of the employees both issuing and receiving it, it's lawful. Unless you have a policy that prohibits employees from using the email system for personal reasons, and you enforce it, which I would venture to say most employers can't.
both of those have to be true. If you have a policy that says your email is to be used for work-related purposes only, but then you spend zero time checking, and you know that people use it to make lunch dates or
that rule is invalid.
So okay.
Yeah. If it's ignored, then it has no merit. No question. Now's the chance.
Committee formed by themselves, like just employees, no managers. Well, there may be managers.
Right.
So the example is a people of color committee, a group that's discussing how they feel about it and how they feel at work, and like it's kind of out of the hands of management.
So yeah, employees that want to form their own groups or committees to meet and talk about terms and conditions of employment, perfectly lawful. It probably would be considered a labor organization, so any action the employer took vis-a-vis that group could be problematic.
Is it okay to allow them to meet during work hours?
Of course, you can do anything. You're the employer. You can say, yeah, you can meet during work hours. But again, if you show favoritism to this labor organization, that could violate domineering of support. would be a violation as well, essentially. Any more questions?
Let's say that you said that the violations of the National Labor Relations Act happen all the time, but they don't necessarily get reported because everybody's playing nice in the sandbox.
Right.
If that comes to the point where you have an internal committee,
Mm-hmm.
and you're working hard to get to improve workplace climate, for example,
Right.
and at some point the employees say, you know what, you're not listening to us, you shut down debate, this isn't a genuine process.
Right.
We're calling and we're gonna report you. What's the penalty? What kind of penalty can an organization expect for
Good
this
question.
kind of violation?
Okay, penalties under the National Labor Relations Act are very limited. More limited, for example, than Title VII. So there's no attorney's fees available under the National Labor Relations Act. There's no compensatory or punitive damages under the National Labor Relations Act. There is only, to the extent that that an employee has suffered financial damages, they can be paid any back pay plus interest for anybody that was discharged. If it's a discharge situation involving just, a committee or posting, then it's not going to have the same outcome in that situation.
So the major thing that could happen is that they could tell you to stop doing it, and you have to stop doing it.
Yeah, they would disband. You'd be ordered to disband the committee. Typically, the relief under the National Labor Relations Act is whatever you're ordered to do or undo, and then you're required to post a notice for 60 days in all languages that your employees use, that you won't violate the National Labor Relations Act, you won't do this, you'll be a good employer.
Even though you were trying to be a good employer.
Even though you tried to be a good employer. Yeah, it's a question of definition.
Right.
Any other questions? Well, thank you all for coming.